Good morning. Thank you for joining us for another installment in our semi-annual series, You Have a Contract, Now What? You're joining us on day two of our three-part installment. Yesterday was the first day, Monday, and the Facilities Management Division shared tips and best practices to be successful upon being awarded a contract with their agency. Today, you're in for a treat. It's the first of two presentations that will be made by the Broward County Attorney's Office. And in case you're wondering, the information that will be shared today and tomorrow will cover different content. So you'll need to join us at the same time tomorrow for the final session. Our presenters have an hour allotted for their presentations, and you'll have 30 minutes after their presentations that will be dedicated to questions and answers. And you'll be able to submit your questions at any time during the presentation by clicking on the Q&A button towards the bottom of your screen and typing your question in the Q&A field. When you registered to attend the series, starting with Monday, you should have received the links not just for yesterday and today's sessions, but for tomorrow as well. In case you misplaced it, the link for tomorrow's session has also been made available for you today in the chat. And now I have the pleasure of introducing Sandy Steed, who is an assistant county attorney in the Broward County Attorney's Office. She practices in the General Transactions Group, where she provides legal representation for the Office of Economic and Small Business Development, our office, and the Employee Benefits section of the Human Resources Division. She also supervises the representation of the Office of Film, the Cultural Division, and the Performing Arts Center Authority. Ms. Steed handles a variety of transactional, administrative, and legislative matters. Prior to joining the Office of the County Attorney, Ms. Steed was an attorney at a highly regarded litigation firm where she was involved in complex litigation and represented healthcare providers in contract negotiations and dispute resolution proceedings. I've personally worked with her and found her to be a wealth of information on various small business related matters that we've worked on together. And while she won't be able to give you any legal advice today, she will be explaining Broward County's standard agreement terms and requirements, some flow down requirements of which both the prime and sub vendors should be aware, as well as the basic elements of a contract. So with that, Ms. Steed, I'll now turn it over to you.
Thank you, Donna Ann. Good morning, everyone. My name is Sandy Steed. As mentioned, I am an assistant county attorney with the Broward County Attorney's Office. It is my pleasure to be here to speak with you all today about contracting with the county and other legal matters that impact your small business from the county's perspective. I would like to first begin by giving a little background about the County Attorney's Office and our role within the county. Next slide, please. The Broward County Attorney's Office is created by charter. Andrew J. Myers serves as the Broward County Attorney, and he's supported by deputies and assistant county attorneys. Our office provides a full range of legal services and perform both transactional services and litigation. We do not handle criminal matters. Our clients include the Board of County Commissioners, Office of the County Administrator, and all agencies under their oversight, and the Supervisor of Elections. Our office is ran similar to a full-service law firm, except we do not represent or provide counsel to the public. Next slide, please. So my presentation today will primarily focus on contracts, specifically an overview of county contracts. I'll provide basic elements of a subcontract agreement and an overview of the Public Records Act. Next slide, please. So every transaction that the county is involved in requires some sort of contract that includes the relationship between the parties, the terms and conditions that the parties are agreeing to, the scope of services, payment terms, and certain provisions that county as a governmental entity must include in its agreements. Because the county is constantly entering into contracts, many of which are very similar in nature, the county attorney's office has developed a number of template agreements that we tailor for each specific contract. And the template agreements includes provisions that ensure that we're compliant with the law, as well as certain provisions that are meant to protect the county as the steward of public funds. Next slide, please. The template agreements are known as BCFs. Actually, go back to that slide. Sorry, I'm a little ahead. Okay. The template agreements are known as BCFs or Broward County forms. They can be found on the county's website under the Purchasing Division Standard Agreement Terms and Conditions. You can also just search Broward County Standard Agreement Terms and Conditions in Google, and the page will come up. BCFs are the starting point for most county transactions. We have a number of different BCFs depending on the type of transaction. The most common BCF is BCF 101, which is used for most general transactions. It's the one that I'm the most familiar with, and most of my contracts begin with BCF 101. The BCF 202 is used when the county is hiring specialized consultants. The BCF 170 is our standard construction contract. The BCF 301 is used for technology products and services. And our BCF 400 series contracts are specific to the airport. So these agreements are usually updated annually to keep up with changes to the law or to make language more concise. So if you're entering into an agreement with the county, it will most likely be on one of these forms. The form is just the starting point, so it will be tailored for whatever specific products or services you'll be providing to the county. Next slide, please. So in addition to the BCFs and the standard exhibits for each, our office has developed a number of other form documents and exhibits that are applicable only to certain contracts. So we have a business associate agreement, which is used when the county may be providing protected health information to a vendor, a work authorization, which is used when approving optional services or goods, a federal funding exhibit, which is used when federal dollars are involved, and it contains federally required provisions. We have sponsorship and grant agreements, which are used when the county is giving grants or sponsorships to individuals and organizations. And then we have concession agreements, which are used to authorize private businesses to operate a facility or provide a service on county-owned and operated property. We find this a lot with our parks agreements, where we have concessionaires that are operating certain businesses on county property or at county parks. Again, although we utilize our forms as the starting point, each agreement is tailored to the specific services. We do business with a lot of different vendors and are entering into many different contracts on a daily basis. So having a solid foundation is very important. As you can see, just about everything we do here at the county is formalized into an agreement. We highly recommend that small businesses doing any work for the county or for any business or individual to do business in writing and formalize everything into a contract. It's the only way to protect yourself and to protect your business. This is particularly important if you're performing services as a subcontractor under a prime contractor that has a contract with the county. Ultimately, the county's agreement will be with the prime contractor, and they will provide very little protection for the subcontractor, which is why it is important that subcontractors formalize their terms with the prime contractor in a formal written agreement. So we will get a little more into that later in the presentation. Next slide, please. As part of our BCFs, there are certain standard provisions that are meant to satisfy state and federal law, local ordinances, and to protect the county as a steward of public funds. We update our agreements annually or as needed to comply with changes in the law. Our agreements can get a bit lengthy because there are many terms that we are required to include in our contracts, in addition to the terms specific to the services being provided. So I will not get into the specific provisions listed in the slide, but these are just a few of the provisions that you will see in a contract with the county that are somewhat unrelated to the services requested. And a lot of times these provisions aren't negotiable because they're required by law or whatever other source that requires us to have them. So if you're trying to negotiate these provisions, usually they will be non-negotiable. Next slide, please. So once the contract has been negotiated between the county and the vendor, and it's ready for execution, the board usually, unless the authority is otherwise delegated, must approve and execute the document. In situations in which the board must execute, even if the authority to sign the applicable contract was previously delegated or given to someone else, when the contract exceeds 5 years or the contract is being extended beyond 5 years through an amendment, then it has to go back, it has to go to the board for approval. So county agreements are typically 5 years or less, but they are sometimes extended through an amendment. The board must also approve and execute contracts that exceed $500,000 in the aggregate, and that's inclusive of any amendments, extensions, and renewals. The director of purchasing is authorized to execute agreements that are less than $500,000 in the aggregate. So to give an example, if a contract has a value of $375,000 for the initial term, but the renewal terms have a value of $200,000, then the agreement would need to be approved by the board, even though the renewals are optional, because the agreement's value in the aggregate exceeds the $500,000 threshold. So for the vendor, an authorized representative must sign on their behalf, either by hand or by digital signature. We also request some confirmation of authority, either through a corporate resolution confirming that the signatory is authorized to sign for the company, or the signatory being listed as a current officer or director for the business on sunbiz.org. Next slide, please. So as a vendor entering into a contract with the county, there are some laws that you should be aware of. One of the most important or most relevant is the Public Records Act. The Public Records Act provides a right of access to records of state and local governments, as well as to private entities acting on their behalf. So if you ever do business with the county, you should at least be aware of the Public Records Act and its requirements. Next slide. A public record is any document or communication, regardless of the means of transmission, that is made or received pursuant to law or ordinance, or in connection with the transaction of official business by any agency, including a private entity acting on behalf of a public agency, that is used to perpetuate, communicate, or formalize knowledge. If material falls within the definition of public record and is not subject to a statutory exemption, it must be disclosed. So if an entity enters into a contract with the county where the entity is providing some goods or services on behalf of the county, that entity will also be subject to the requirements of the Act. So this means that the entity must keep and maintain records required by county to perform the services, provide county with a copy of any requested records, or allow the records to be inspected or copied within a reasonable time. And once the services are completed, or if the agreement is terminated for any reason, transfer all documents that are considered public records to the county or keep and maintain them. All records, all requests for public records must be made directly to county, who will be responsible for responding to any such public records requests. So if your business ever receives a public records request, make sure you either forward the request to the contract administrator, or you can tell the requesting party to send their requests directly to the county. So if you're doing business with the county, you shouldn't be handling public records requests on your own. That's something that's the county's obligation. So we request that you reach out to the county if you ever receive a public records request. Next slide, please. Public records must be disclosed unless there is a statutory exemption from disclosure. One such exemption may be relevant for businesses is trade secrets. So any material that a vendor claims constitutes a trade secret as defined in Florida statute section 688.002 must submit the trade secret materials separately and must clearly label the materials as exempt from public production due to trade secret and the factual basis for the designation. So if county receives a public record request for documents, that have been properly identified as trade secrets, the county is prohibited from disclosing the trade secret unless ordered by a court or authorized in writing by the vendor. When a public record contains information that is exempt from disclosure, the record's custodian must redact the exempt information and disclose the remainder of the public record. So generally, entire documents can contain trade secret information. So it's important to properly label documents that contain this type of information. Otherwise, the information can be inadvertently disclosed. Also, you must ensure that the documents that you are identifying as trade secret material or any other identified exemption actually meet the statutory requirements, because the requester can file a lawsuit, and it has happened, for failure to disclose public records. And the county will seek indemnification from the vendor who has requested that the documents not be disclosed, which means that the vendor will have to defend the county in the lawsuit and basically prove that whatever reason they provided or whatever exemption they cited to is actually correct, and that the documents should not have been disclosed. Next slide, please. So essential elements of contract formation. The essential elements of a legally binding contract include an offer, acceptance, awareness, consideration, capacity, and legality. The first element is an offer, which is basically someone wanting a product or a service that someone else can provide and offering something in exchange for that product or service. Once the offer is presented, the offeree can decide whether to accept or reject the proposal. Both parties must first be aware that they are entering into an agreement, which is often called a meeting of the minds. So one party can't, basically think that they're entering into an agreement, and the other party is like, I didn't realize that we were agreeing on something. I didn't realize that this was creating a contract. So both parties have to be aware that they are actually creating a contractual agreement. There must be some sort of consideration or something of value provided, such as money, property, services, etc. All parties must understand the obligations, terms, and consequences of the contract before signing and demonstrate legal capacity. So minors, someone under the influence of drugs or alcohol, or someone who does not understand the language used in the contract would not be considered to have legal capacity to validate a contract. And finally, the contract must not be for an illegal action or product. Otherwise, it is unenforceable, because the court will not enforce a contract that's for something that's illegal. So when these 6 elements are present, a contract evolves from a simple agreement into a legally binding document and is now enforceable against either party. Next slide, please. Okay. So as I previously mentioned, if you are doing business with someone, you should always formalize the terms by entering into an agreement or contract. These terms are used interchangeably, so they both mean the same thing. Although the actual content of an agreement can vary greatly based on the services or products being requested, there are some components of a contract that should always be present. Whether you are entering into a contract as a prime contractor or subcontractor, you want to make sure that the agreement includes these basic elements. So if you're drafting the agreement, you can tailor the language to favor your business. And if you're reviewing a contract that someone else wants you to sign, you want to make sure that you agree with the terms and that they are not too one-sided. Next slide, please. So the first basic component of an agreement is the parties. Who is entering into the contract? It is important to specify who is a party to the agreement, because you generally cannot enforce an agreement against someone who isn't a party to that agreement. Like I said before, there has to be a meeting of the minds. So the parties have to know that they're entering into an agreement. You want to make sure that the individuals or entities who are going to be performing the work or paying for the work are included. I have incorporated some snippets from our BCF 101, which is the most commonly used form for the county for illustrative purposes. So this portion identifies the parties to the agreement. So as you can see, you have Broward County and then whatever the entity's name is. And then you will say what kind of business they are, whether it's an LLC, a corporation, and you have the parties defined. So Broward County, traditionally in our agreements, we're defined as county. So throughout the agreement, you will always see Broward County referred to as county, unless we're referring to like Broward County, Florida, as the location. And then the other party that's entering into the contracts will be defined. And then RBCF 101, the standard term is contractor, but you may see them defined in other ways in an agreement. Next slide, please. Next is the term, or when the agreement begins and when it ends. This is important because the obligations of the agreement generally begin and end based on the time frame specified in the agreement. So when the agreement ends, usually the services does as well. So what you want to make sure is included in your agreement is whether or not the agreement can be extended. If so, how? Must it be in writing? Must both parties agree to the extension, or can it be done unilaterally? In the county's agreement, our agreements they can vary, but generally you will find that there's a 3-year initial term and then 2 1-year extension terms, which means that the first 3 years, that's going to be the initial term of the contract, and the 2 remaining years are optional. And usually the extension can be unilateral by county, as long as the county provides written notice of the extension. And we would have to do that after the first renewal term, and then in order to go into the second renewal term, and after the initial term in order to go into the first renewal term. Next slide, please. Most importantly is the compensation. How much are you paying or getting paid for the services? How often? Is it monthly, annually, after the service is provided, etc.? How does billing work? Does an invoice need to be submitted? And how long after receiving the invoice will payment take place? How will payment be made? Will it be via check, Zelle, cash, bank deposit, etc.? Are there specific requirements that must be met before payment? And are there different payment terms for different services? So in the county's agreement, for example, it can vary greatly depending on the type of services that are being provided. So the payment can be made via check. It's never via cash. I don't know if I've ever seen a county agreement that's via cash. It can be made via ACH deposit in some cases. So in your agreement, you want to make sure that it clearly specifies how the payment will be made, when it's going to be made, how payment is made for the various types of services under the agreement, because there may be times where you want to make sure that a specific service is provided before payment is made. And there may be times where the payment is made up front before the service is provided. So you want to make sure that if that is the case and you have those types of services in your agreement where it's paid on the front end and paid on the back end, then you want to make sure the agreement clearly specifies for each scenario how payment is going to be made, so that when that time arises and you aren't paid accordingly, you can go back to the agreement and say, hey, the agreement says this, so I expect my payment by this date in accordance with the agreement. Next slide, please. So next is the scope of services. Essentially, the scope of services should spell out who is responsible for doing what, who will be providing or performing the services, what services or products will be provided, when will they be provided, where will they be provided, why are they being provided, how will they be provided, and how often. So basically who, what, when, where, why, and how. Are there any reporting or progress requirements? Generally, the county has a scope of services as a separate exhibit, but you can spell this out in the body of the agreement as well. It doesn't have to be a separate exhibit. You just want to make sure that it's clear what this contract is for and who's going to be doing what and when are they supposed to be doing it. So it's very important that the contract lays out what the services are and how the parties contemplate the services to be provided. Next slide, please. Termination. So although we don't go into any relationship thinking that we will ever have to terminate it, it's important to always have language that addresses that situation if it ever does arise. So it's kind of like having a prenup. You know, you go into the relationship thinking that it's going to be great, but if something does happen, you want to make sure that you are protected. So you want to make sure that the contract addresses who can terminate the agreement, for what reasons, what happens when the agreement is terminated, are there any obligations post-termination, such as returning documents or materials, providing any reports, etc. Can termination be verbal or must it be in writing? And in what time frame? Are there any notice requirements prior to termination? For example, in counties BCF 101, either party can terminate for breach within 10 days after written notice if the breach isn't corrected within that time frame. And that can vary from agreement to agreement, but that's just in the standard BCF 101. So for some services, 10 days may not be a sufficient amount of time. So you want to tailor your termination provision to suit whatever services you're providing. Also, if you want to include any specific termination rights, such as liquidated damages, or events that would trigger the right to terminate, such as bankruptcy, or if they stop providing a specific service that's necessary under the agreement, then you want to make sure that it's included in your contract as well. Next slide, please. So some other terms that you may want to add include third-party claims and how they will be handled. For example, if someone sues you as the prime contractor for the actions of the subcontractor, you may want the subcontractor to indemnify and defend you against those claims. Also, depending on the type of services being provided, you may want to consider including insurance requirements. You would also want to specify what laws govern the agreement and what venue any lawsuit related to the agreement should take place in. You may also want to consider including an arbitration provision that will require the parties to arbitrate their claims before they can file a lawsuit. And other miscellaneous terms that you think are relevant to your agreement. Next slide, please. So although the county's contract is with the prime contractor, and all of the terms that I previously mentioned are terms that are covered under the county's BCF provisions, there will be certain provisions that are applicable to both the prime contractor and the subcontractor. Because the subcontractor is not under contract with the county, these provisions must be passed through the prime to the sub to ensure that the requirements are met. It is the prime contractor's responsibility to ensure that their subs are complying with those specific provisions. The best way to do this is to include those provisions in the subcontract agreement. You can identify these pass-through provisions in the county's contract with the prime by the way they are worded. So on the slide, there are two examples of pass-through provisions. So the first one requires the prime cause the sub to submit an ownership disclosure form. So this doesn't specifically require that the provision be included in the subcontract agreement. However, including it in the subcontract agreement will allow the prime to enforce this requirement, or at least put the subcontractor on notice that this is a requirement. The second example specifically requires that the prime include the applicable provision in their subcontract agreement. So the highlighted language says contractors shall ensure that the requirements of this section are included in all contractors' agreements with subcontractors. So that one's much clearer that that provision must be included in your subcontract agreement. So if you have a contract with the county, you want to make sure that you are including all of the pass-through provisions in your subcontract agreements. If you are not using any subcontractors to perform any of the services, then this would not apply to you. Next slide, please. So if you're providing goods or services pursuant to a county contract, whether as the prime contractor or subcontractor, you want to first review the contract. In a prior slide, I mentioned that county is subject to public records laws, which means that you can request a copy of the applicable contract. Section 35.20 of the Broward County Administrative Code provides the fees related to duplicating records. I believe if it is a newer contract that's requested and it's sent via email where it doesn't require much research or work on behalf of the county to find and send, there may be no fee involved, but do not quote me on that. I recommend reaching out to the agency that has the contract or who the contract is for and request a copy of the contract. And if you're unsure what agency it is, then I presume you can reach out to OESBD and they can guide you in the right direction. If you are a prime contractor or even a subcontractor, you want to make sure that you formalize any agreements resulting from the county contract. If you are the prime, you want to make sure that the agreement reflects the entirety of what the parties agreed to and that the agreement doesn't lean too heavily in favor of the prime. You want to make sure that the basic components are included in the contract. Contracts are meant to be negotiated, so don't feel obligated to just accept whatever agreement the prime puts in front of you. Look at it, decide whether or not you feel comfortable with those terms and whether those terms make sense. Don't just sign whatever is put in front of you. Seek legal counsel to prepare and review agreements. So this presentation, I work for the county attorney's office, so this presentation is not meant to be legal advice or legal guidance. I'm just telling you the type of provisions that the county usually includes in its contracts and that may be useful to primes and subs that are entering into their own agreements. So it's important that if you have any questions regarding your own agreement, that you seek legal counsel to prepare or review the agreement. And if a prime is handing you a 50-page agreement that makes your eyes cross, you should seek an attorney to review it and let you know if there are any concerning terms. If you need assistance with drafting a contract, you should reach out to an attorney. And then if an attorney is not in the budget, which sometimes is the case for small businesses, then there are a number of other resources out there that you can utilize to assist with putting together a basic agreement. There are websites that have template agreements that you can modify. There are even websites that have agreements that they'll put together for you once you enter in certain information, they'll basically craft the agreement for you. So that's also an option if you are unable to afford an attorney. But bottom line is, if you really do need the assistance, it makes sense to pay on the front end, to have an attorney review and make sure that everything is right, or it can cost you on the back end. So reach out to OESBD for assistance. They are there to be a resource for small businesses. And if they do not have the answer, they can at least point you in the right direction. And finally, understand your role and responsibilities under the county's agreement. If you are a prime, read and make sure you comprehend what you are agreeing to before signing off. This should actually be done before even submitting a response to a solicitation. So the contract is provided to you as part of the solicitation package. A lot of times this is done via a link to the purchasing's website, which has all the basic county forms. And sometimes you'll have project-specific agreements that are basically like a BCF 101 that's tailored to those specific services, because the standard BCF 101 doesn't contain all of the terms that are necessary for that transaction. You also have access to all of the county's template agreements on the purchasing division's website. If you do not understand something, ask questions, but make sure you do not violate the cone of silence. I'll get into cone of silence a little bit more in the next slide, but the presentation tomorrow is going to cover everything you need to know about the cone of silence and all things procurement related. So I suggest if you have any questions about procurement or you're interested in doing business with the county or responding to a solicitation, then I suggest and recommend that you attend the presentation tomorrow. Next slide, please. So how to avoid common pitfalls. So there are a few ways to avoid common pitfalls when doing business with the county. In the solicitation phase, first and foremost, understand what is being requested. I cannot stress that enough. If you are submitting a response to a solicitation, make sure you review all components of the advertised solicitation, including the pricing, the scope of services, the responsibility and responsiveness requirements, because you can be kicked out of the solicitation process if you aren't responsive and responsible. The terms and conditions and any special conditions. So make sure you submit all requested forms, submit responsive pricing, and answer all eval criteria questions. And do not send an incomplete bid response. That is a waste of your time and a waste of everyone's time if your bid is not complete and it gets kicked out because it's not complete. Because I understand that it takes a lot of time to prepare these responses. So it would be very unfortunate for your response to not be even considered because it's incomplete. Next, only commit to what you have the capacity to undertake and or subcontract. Adhere to the cone of silence, which can be found in section 1-266 of the Code of Ordinances. The cone of silence essentially prohibits communication between a vendor and certain county personnel and commissioners. It is important to know when the cone of silence is in effect and who you can and cannot communicate with while it is in effect, because violating the cone of silence can lead to fines or even debarment. You can get more information regarding the cone of silence in tomorrow's presentation. And last but not least, make sure to review the summary of vendor rights, which is included in the advertised solicitation, or at least referenced there. And if you cannot find the summary of vendor rights, you can reach out to someone in purchasing and they can assist you with accessing that. So once you've graduated from the solicitation phase and have actually been awarded a county contract, or if you're participating as a subcontractor under a county contract, make sure all understandings are formalized in writing. It is not enough to just have a verbal agreement with someone, because although we assume that most people go into these transactions with good intentions, sometimes things do not work out as verbally agreed to, which is why it is very important to formalize everything that you have agreed to in writing. And if you have an agreement that doesn't include everything that you agreed to, the issue you will have is trying to enforce certain provisions that aren't included, certain agreements that were made outside of the agreement. I recommend that you request a copy of the county's agreement with the prime if you don't have it, and review the terms of that agreement so that you understand what the prime's obligations are under the agreement. You understand what the prime's role under that agreement is, and you understand what the prime's responsibilities under that agreement are. And so you understand the payment terms, because sometimes that can impact your payment terms as a sub. So you want to make sure that you have a complete understanding of the county's agreement with the prime contractor. And you want to understand your role and responsibilities under the agreement. Communicate with the contract administrator if you have any questions related to the agreement or the services, and reach out to OESBD for assistance when needed. Next slide, please. So in conclusion, there are many opportunities for small businesses to do business with the county. Our county business enterprise and small business enterprise programs are just one way to get your feet in the door. OESBD is a great resource for all things small business, and they are really a useful resource in terms of providing programs that are geared towards small businesses, as well as providing resources and guidance to help grow your small business. Thank you so much for your time, and I hope that you found this presentation useful, and I will hand it back over to OESBD for questions.
Thank you so much. I saw the comments flying. Ms. Steed, excellent, very useful information, and we thought so too. So with that, we're going to invite you. If you do have any questions, please feel free to go ahead and put them in the Q&A area. And there's one there right now that I'll read aloud. Should I use that section when I utilize subcontractors, such as therapists, for my mental health and wellness trainings? Murnette, I'm going to ask you, because you probably put it up when there was a specific slide that was being shown. If you could give a little context to the information that you were asking about, if you should include in your subcontract agreements. However, I should add, at the beginning, I said Sandy can't give you legal advice. I will let her chime in, of course, but if it's specific legal advice, she may not be able to. If it's a clause in a Broward County contract that you're asking about flowing down into your subcontractor, then I'll let her answer that.
Yeah, so if you can, I guess, can she come off mute and say, or put it
She said it was a clause. So if you're saying it's one of our clauses, Murnette, that you wanted to know if you should put in your okay. Then I think she's referring to maybe the flow down clauses or something in her own primary contract that she would want reflected in the subcontract, Sandy.
Yeah, so if there is any agreement, if you're working under a contract with the county and you are the prime contractor and you are utilizing subcontractors, then yes, the pass-through provisions should be included in your agreements with your subcontractors. I hope that answers the question.
And subconsultants.
And subconsultants, right.
Okay, anybody else with any other questions? It is not often that we have representatives from the county attorney's office in such a captive environment. So if you do have any questions, again, Ms. Steed can't give legal advice, but if you do have any questions about anything that she's presented thus far, feel free to enter it in the Q&A box, and you're very welcome, Renat.
So I jotted down a couple of questions because as a panelist, I can't use the Q&A, and hopefully this might get somebody else thinking. And it's just curiosity. I'm not a business owner, but for termination, you compared that to a prenup. So is there a post-nup option for termination agreements?
Well, if you amend the agreement, sure, you can add additional termination rights that way. So I guess that could be considered the post-nup.
So just amendments to the contract.
Sure. Yeah.
So that's allowed. And then the second one was about redaction. So outside of trade secrets, is there any other information that can be redacted?
Yeah, there are a number of exemptions to the Public Records Act. So like social security numbers, certain, like, for example, like the county attorneys who work for the county, or state attorney, like assistant state attorneys, a state attorney, like their information is confidential and exempt from public records. So if someone puts in a public records request, let's say they're requesting my address for whatever reason, that would be exempt from disclosure. So they can't request that they can request it, but they won't receive that kind of information. And if there is something that's being disclosed that contains that information, it will be redacted.
Thank you.
Thank you. All right.
Usually we try to redact if the other information is not, it's subject to disclosure. So if it's just general information and you just happen to have like a social security number, but the other information is otherwise subject to disclosure, then we would redact just that social security number and still we would disclose that document.
Thank you for that. Well, I think your presentation was so thorough. that you answered the questions that anyone would have asked subsequent. So we do have a couple more slides with some additional information. I guess if there are no other questions, I see something just popped up. One second. Can we use laws from other states? Well, it would be a Broward County contract. So I'm thinking Broward County laws as well as the state of Florida, but I'll defer to Sandy.
Yeah, I mean, if it's a county contract, then it's going to be governed by the laws of the state of Florida. But if you have another contract that you want to be governed by some other laws and enforceable in another state, then sure. But for purposes of our Broward County contracts, it's going to be the state of Florida laws that are applicable.
Thank you for that question. All right. I think we have a couple more slides just with some general information. And now is a really good time. Sandy queued it up nicely. Tomorrow's session, and we have a slide for that. So let me deal with what's on the screen right now. Many of you have already heard and should be aware that Broward County is transitioning from our current Periscope S2G procurement platform to a bonfire-powered platform that we're going to be calling BPRO. If you have not already done so, please be sure to go ahead and register your company. Registration is entirely free. You can use the QR code on the screen right now. Once you are landed on the purchasing division's page, there are instructions to guide you through the registration process. It's pretty quick, pretty seamless. It's information about your company, the services and the goods that you provide, the points of contact. Basically everything we need to know if we needed to give you a check. So everybody that does business with Broward County has to be a registered vendor. We're told that BPRO is going to go live sometime in September. I would hedge it and say maybe September, October, just to be safe. In the meanwhile, any solicitations that are out there on the Periscope S2G platform will remain there and continue until they're eventually phased out and they're no more there, and then we're completely transitioned into BPRO. So it's a good idea to be registered in both, and there are links on the purchasing division webpage that will allow you to do so if you haven't already. And I saw something flash in the Q&A, just one second. Does pricing provide a contingency for increase inflation for current years? Example for 3 years agreements. Excellent question, Renette. I'm not sure if you were with us yesterday. We had a presentation from the Facilities Management Division, and they actually talked about provisions and contracts, well, provided the language is there, that would allow for increases, whether it's based on living wage increases, which are timed with renewal terms of those agreements, as well as some contracts may have language built in for price escalations, but they don't all do. So Sandy, I'll ask you to round out that response.
Yes, that's exactly right, Donna Ann. Usually, like if the contract is subject to living, which is not all of them are, then there would be language in there that addresses price increases or escalation and rates and things of that nature. But if it's not subject to living wage, sometimes it's a fixed price, so it's that price for the term. And maybe in the renewal term, you can request an increase or something of that nature. But generally speaking, if it's not subject to living wage, it's usually going to be that price for the term.
And something else that was mentioned in yesterday's presentation, particularly with the living wage, if it's applicable, it's something you're going to have to build into your proposal that you submit. You should take into consideration that if increases occur, it's usually, I think, January 1st of every year. So depending on the length or duration of your contract, if you know what the current living wage rate is, you're going to want to forecast potential increases in subsequent years, because even though the living wage rate may increase, it's not an automatic increase to the reimbursement. So those aren't automatic and don't run parallel, just something to keep in mind.
Yeah, I want to add to that, Donnie, if it's not subject to living wage, you also want to keep in mind that you're agreeing to this pricing for whatever period of time the contract is. So you want to make sure that you consider the future and where your business is going to be and whether or not you can sustain making that amount of money for whatever period of time it is. So if you foresee that you will need an increase at some point, then you may want to build that into your pricing. Because I know sometimes vendors find that, oh, if I submit the lowest price, then I'll win the bid, and then later on they can't afford to continue performing the services because they run out of money, because they didn't charge enough for whatever the service is. So it's important that you consider all of that when you're submitting your solicitation response package.
Agreed. Yes, to answer your other question, the sessions are being recorded, but you're going to have to give us a few days to get them uploaded. They'll eventually be uploaded to OESBD's YouTube page. So keep an eye out for that. The sessions that we also held in March of this year, because it's a semi-annual series, we'll do it twice a year. So we'll be back in the first half of the year next year with another 3-day installment. Okay, I think we answered all of those questions. So I'll go back to the slides on hand. If I could ask the team to advance to the next slide, please. Okay, this is for the benefit of everyone in attendance. The South Florida Anchor Alliance has formed a regional marketplace, which is comprised of 11 anchors, essentially 11 different entities, both from the public and private sector. They include Broward County government, Miami-Dade County government, Broward County schools, Miami-Dade schools, universities, hospitals, and each one of these anchors on its own spends approximately $1 billion in the procurement of goods and services. So 11 of us together, that's quite a bit of resources. If you use the QR code on your screen, registration is free, and you'll be able to view the solicitations from all the anchors, from all the other anchors. I should add, we don't all share the same certification or small business requirements. That's something we're working on to come in the future. So it's not one-stop certification for all, but it is one-stop viewing for solicitation requirements. May I have the next slide, please? Okay. If you're curious to know when we're going to be coming up with other technical assistance trainings, such as this one and others, why don't you sign up for our Business Assistance Weekly, or our BAW, as we refer to it. You can do so by sending an email to econdevinfo@broward.org. You can also follow us on our social media pages, which are all on the screen right now, including a QR code. Our director, Sandy Michael McDonald, is very active. I sometimes joke that he single-handedly has more followers on LinkedIn than the whole office combined, but that's how you'll find us. And while I'm talking about events, I should add, the Florida International Trade and Cultural Expo is one of our 2 signature events that OESBD hosts. It is coming up. It has more of an international trade spin on it. So if you are a provider of goods and you're interested in trading with other countries, it's well attended. We have an entourage from all over the globe that attends. Admission is free. This year, it is going to be October 23rd to the 24th. It's held at the Broward Convention Center, and registration is going to open soon. It hasn't yet opened. General admissions registration deadline is October 15th. And you can also inquire about having a booth there or displaying there. So that's something to look out for, and we'll be posting more information in our BAW in the days to come. There is a question that just popped up. Give me one second. We've been part of the Broward County Convention Center East expansion as a 3rd-tier contractor for records and sales taxes. What documents should we have in file? So, okay. I'll take a stab at that, and then let me know if I'm not answering your question, Marcella, if you meant something else. Typically, when our vendors are working, whether as 1st tier, 2nd, 3rd tier, regardless, on a contract, even if they're the primary vendor, there are a few things that they need to retain in a file. I can't advise you specifically for sales taxes, but I can tell you in the case that you're the subcontractor, I would advise you to keep on hand all invoices that you've submitted. Keep a really good record of what's been paid and not been paid. Anything that's outstanding, be mindful that for every contract that has small business participation requirements, there is an assigned specialist within our office that's monitoring that for compliance with the applicable small business program. So if you run into an obstacle, you can definitely reach out to us. I happen to know off the top of my head, and he might be listening, that our small business development supervisor, Oswaldo Casco, is monitoring this contract for compliance. So you can definitely give us a call. The number for the main office is 954-357-6400, or you can email me or Oswaldo. His email is O as in Oscar, C as in cat, A as in apple, S as in Sam, C as in cat, O as in Oscar. So it's O Casco at broward.org. And my email is D as in Donna, followed by my last name, K as in King, N as in Nancy, A as in Apple, P as in Peter, P as in Peter, DNAP with 2 P's at broward.org. And if there's a specific issue, we'll try to help you work through it. But if you're asking about general records, I would say keep track of everything that you're owed for the work that you've done. If you're the prime in that instance, I know you said you're the 3rd tier. We also ask you to keep records of any disputes regarding work. It could be change order work, whatever it is, and we'll try to help. There are certain elements of disputes. If they're not violations of the small business programs, we can't directly intercede, but we can assist with a mediation meeting. If you want to talk more about specific support docs that you should have on hand, definitely give us a call. I know that there are some tax exemptions for certain goods that are purchased under the convention center contract. So it might be specific to that agreement. Let's talk some more offline. Okay, perfect. Thank you so much for your question. All right, I think that's it, everyone. I really appreciate the time that you took to listen in. I found our webinar today very insightful. Join us tomorrow for part 2. We'll have another representative from the Broward County Attorney's Office who'll be tackling a different set of topics, which include the cone of silence and violation of the cone of silence and the consequences thereof, when it starts, when it ends. They'll also be addressing appeals, protests, the timing that are allowed for them, within which you can submit them, the circumstances under which you'd be allowed to protest, object, and appeal. So definitely tune in tomorrow at the same time. The link was provided in the chat. So if you haven't already signed up, go ahead and register. We're going to have some more really good information for you. Thank you, everyone. Thank you, Sandy. Thank you, team. And we'll see you here back again tomorrow at 11 a.m. Thank you so much.
Thank you.